So I see that we've got a good number of people joining us today or here already. So why don't we get started? So welcome everyone. Thank you for joining us today. Want to thank the Mass Charter Public School Association for inviting us to join you today to talk about the Title IX updates and to answer some questions that you have about the 2024 updates to Title IX. So my name is Bettina Toner. I'm an attorney with the law firm of Krokidas and Bluestein. I'm an attorney in the education and employment practice groups, where I represent mostly Massachusetts charter public schools, as well as other public and private educational entities here in Massachusetts. So I represent those clients in a wide range of matters. So everything from student services, student discipline, civil rights, compliance. I also do litigation in all of the areas that we cover. And I also do quite a good deal of employment matters or employment law matters for our charter school and other educational clients. Just a little bit about K&B before I introduce my colleague, Eric Jordan. K&B is a full service firm for our charter school clients. So in addition to all of those things that I just talked about, that I do for the charter school, for our charter school practice and educational practice, K&B also does other things. So real estate acquisitions, and we do a lot of board governance matters, financing, lobbying guidance and advice on lobbying and political activity, really sort of the whole range of legal coverage that charter schools require. We do it here at K&B. So with that, let me hand it off to my colleague, Eric Jordan, who will tell you a little bit about his practice, and then we'll get started.
Yeah, thank you, Bettina, and good afternoon, everyone. My name is Eric Jordan, and as Bettina mentioned, I am an attorney at Krokidas and Bluestein, where we represent educational institutions in the wide expanse of their needs. And so we do work ranging from regulatory compliance and corporate governance to special education and student discipline. Prior to my joining the team at K&B, I worked in higher education, where I conducted Title IX investigations for students, faculty, and staff, facilitated informal resolutions, participated in hearings, and conducted Title IX trainings. And so we're looking forward to discussing Title IX and the 2024 regulations with you all today.
Thanks, Eric. So with that, as promised, we do have a lot to cover today. So this is just a high-level overview of the agenda. The new Title IX regulations, as I previewed for you, are really quite detailed. So we'll do our best to flag all of the important changes that you need to be aware of as a charter school. You will, of course, want to consult with counsel on any specific questions or anything, fact-specific or detailed that you need guidance on. Just a reminder that you can submit questions today a couple of ways. So some folks have submitted questions already, and we'll get to a good number of those today at the end of the presentation. But during the presentation, you can also add questions in the Q&A using the Q&A function, and we'll get to as many of those as we can. Those that we don't get to, we will put together in an FAQ document that we will circulate to all attendees. And we will also be sending out a copy of the slide deck today, so you don't need to take copious amounts of notes. We will send you the slide deck and the FAQ in about a week or so. So with that, I am going to hand it back to Eric, who is going to kick us off.
Yeah, so we wanted to start today's webinar by just kind of giving a sense of the Title IX language and where it comes from. So ultimately, Title IX comes from the Education Amendments of 1972. And the language of Title IX states that no person in the United States shall, on the basis of sex, be excluded from participation in, be denied the benefits of, or be subjected to discrimination under any education program or activity receiving federal financial assistance. And so this has implications for admissions, athletics, employment, and academics. And the thing that brings us together today is the fact that there were amendments to those Title IX regulations that went effective August 1st of 2024. And so there are particular things that we like to be able to cover with you all as explained in those regulations. So if we move along to the next slide, there are a few things that are required for Title IX compliance, each of which we'll go through in greater detail over the course of this webinar. But just by way of an overview, to be in compliance with the 2024 Title IX regulations, the school must designate a Title IX coordinator. It should adopt, publish, and implement a non-discrimination policy and grievance procedures. And that non-discrimination policy should state that the school does not discriminate on the basis of sex and that it prohibits discrimination on the basis of sex in its education programs and activities. A school should respond promptly and effectively when it has knowledge of sex discrimination. It should publish its notice of non-discrimination. And a school must also make sure that all people involved in the Title IX grievance procedures are appropriately trained and that all appropriate Title IX records are maintained. And so we're going to get into each of those over the course of this webinar. And I'm going to go ahead and transition back to Bettina, who's going to go into detail for some of the language of Title IX.
Thanks, Eric. All right, so let's talk first about changes in definitions. So definitions under Title IX are big, right? So the 2024 regulations emphasize and clarify protections against discrimination and harassment based upon sexual orientation and gender identity, as well as discrimination based on sex stereotypes, as well as pregnancy and related conditions. But these protections have arguably always been included under the umbrella of discrimination based on sex, right? Particularly under Massachusetts law, and are often included in school policies as well. So this, in some ways, probably doesn't seem like a new concept to folks. So again, just as a reminder, under Massachusetts law, schools are prohibited under state law in a number of contexts from discriminating on the basis of sex. So talking about some of those pre-existing protections under Massachusetts law. And it also, folks may recall that DESE has some guidance on non-discrimination of students on the basis of gender identity. That's a few years old at this point, but that just goes to show that this is concepts. These protections are concepts that schools have been familiar with for several years now. So the last one I also just wanted to mention. So again, just a reminder, we oftentimes in school settings are thinking about Title IX in the context of students and student services, but it does also apply in the employment context as well. And so under the Mass Pregnant Workers Fairness Act, which obviously applies to employees, there's been this similar protections as those that have been incorporated into the 2024 regulations, the Title IX regulations. So a little bit more of a deep dive into Title IX definitions. Sex-based harassment, right? So under the 2020 regulations, there was a lot of emphasis on sexual harassment. Under the 2024 regulations or amendments to Title IX, there's much more of a broad focus on discrimination on the basis of sex more broadly. But sex-based harassment, therefore not sexual harassment, but sex-based harassment is a form of sex discrimination. And it means sexual harassment, of course, and other harassment on the basis of sex stereotypes, sex characteristics, pregnancy and related conditions, sexual orientation and gender identity that falls into one or more of the following categories. So some of this might look a little familiar for those of you that are familiar with the 2020 regulations. This concept of quid pro quo harassment, hostile environment harassment, and sexual assault, and the sort of what we have often referred to as the VAWA offenses. But they are a little bit different under the new regulations, and this is an area where folks are going to need to be familiar. You want to make sure your staff are familiar, that the definitions are different. So quid pro quo harassment, which was a concept that was included under the 2020 regulations, means when an employee or agent of the school conditions the provision of an aid, benefit, or service of the school on an individual's participation in unwelcome sexual conduct. Sort of like, I'll give you this if you do that sort of concept. It can be employee on employee harassment. That's very oftentimes when this type of scenario comes up, quid pro quo harassment. Or employee on student harassment. If you do this, I'll give you an A in class kind of thing. It's typically not student on student harassment. It's not to say in some of the higher ed contexts that this couldn't come up. It's not likely to come up in the context of K through 12 schools, the student on student harassment. And then, of course, we have this concept of hostile environment harassment, which again is not a new concept, but the definition is different. So something new for folks to become familiar with. So under the 2024 regulations, the definition of hostile environment harassment means, and we'll unpack this a bit on some of the upcoming slides, but it means unwelcome sex-based conduct that is subjectively and objectively offensive. And that it's so severe or pervasive, that's not a new concept, but we'll talk about it a little bit more, that it limits or denies a person's ability to participate in or benefit from the school's education program or activity. So we'll unpack hostile environment harassment a little bit more as promised, but also included in the definition of sex-based harassment is, of course, sexual assault, dating violence, domestic violence, and stalking. That is not new under the new regulations, but just a reminder that it's included. So again, this sort of big takeaway in the shift in definition from 2020 to the 2024 regulations is this focus on sex-based discrimination and less on the more narrow idea of sexual harassment that we saw under the 2020 regulations. Okay, so let's talk about hostile environment, because this is, I think, if for folks that practice in this area or handle these types of cases, this is very often where Title IX violations come up, at least in the K through 12 context, in my experience. So hostile environment elements, unwelcome sex-based conduct. That's pretty straightforward. That based on the totality of the circumstances, so the big picture, is so subjectively offensive. So it means offensive to the particular person involved, the complainant or target, and objectively offensive. So to a reasonable person in a similar circumstance, right? And that is so severe or pervasive. Again, this is not new. This is a similar concept to 2020 regulations, that it limits or denies a person's ability to participate or benefit from the school's education program or activity. I do want to so that's sort of like the big picture of hostile environment. I do want to just note here, and this may come up again later in questions, when you're considering hostile environment, it's not just in the context of, or needs to be considered not just in the context of the particular students involved or employee, students, whoever's involved, but typically the climate and culture piece that I want to talk about comes up in the student context. And it's important to remember that a hostile environment can be created and affect someone who is not the target of the conduct or speech, okay? So we'll talk about that a little bit more, but I always give the example of there's a group of students telling jokes that are offensive, that either include, offensive sex-based comments, and they're not targeting at someone. They're not saying to someone in particular, maybe it's just general jokes and they're being loud, but that could be overheard by someone and be considered to create a hostile environment, depending on the facts. So it's very important to always consider when there's an allegation of sex-based discrimination or allegations of conduct or speech that might be a violation of Title IX, to consider the impact on the climate and culture. Okay. So unpacking hostile environment a little bit more, a couple of things I just wanted to mention when you're thinking about severe. A lot of times this seems very straightforward, but a couple of things that you could take into consideration when you're considering, like, is this severe, is it not severe? Typically, some things to think about, whether the conduct was physical. Usually physical conduct or behavior is more severe, maybe more severe than written or verbal behavior, speech conduct, but not always, but this is just kind of general guidelines. Also, you want to think about, when you're considering severity, was the conduct accompanied by threats or was there violence involved? When you're thinking about pervasive, some things to consider: frequency, repetition. Did this happen one time? Did it happen many times? Does it happen every day or every bus ride or that sort of thing? The scope. So how many folks were, how many targets were involved, how many respondents were involved, and widespread impact, again, thinking about climate and culture at the school, where there are multiple targets, so on and so forth. Okay. So when we're talking about totality of the circumstances, again, thinking about frequency, nature, and severity of the alleged conduct, presence of threats or violence. But you also want to think about when you're considering the totality of the circumstances, sort of piece of the hostile environment definition. The relationship between the parties. Was this a couple that had been engaged in a romantic relationship previously? Are they total strangers? The age and maturity of the parties. Are these, is this a second grader that, hits another second grader on the butt on the playground? Or is this, a situation between, same conduct, but are these high school students in the hallway? The nature and context in which the conduct occurred is important as well. So, we could spend a lot of time talking about on-campus versus off-campus behavior, but that context might matter as well. I mean, certainly you want to take into consideration the whether off-campus conduct spills over and creates an environment at school, but the context can matter. Did this happen over the summer? That's the only time it happened, not in school, not on school grounds, and so forth. And then you want to think, this is maybe not so relevant for charter schools, but when I talk to some of my Chapter 766 schools, you might also consider the nature of the school's program and the population of students served. So behavior that might be exhibited by a student in a therapeutic residential program might not be assessed in the same way it would for a student in a K through 12 just charter school. So again, some things to think about when you're thinking about hostile environment. And I know this is a lot of information. I want to just sort of make sure that we get through all of the high points, but folks will get the handout. And of course, if you have questions, feel free to ask them, and you can always ask after the presentation as well. Excuse me. So I did just want to just talk for a couple of minutes about legal challenges to Title IX. I often get, and Erica also gets questions as well about, how do these, I read in the newspaper that, Title IX is being challenged by the state of Kansas. What does that mean? Or schools. I've had a couple of charter school clients that have students, families that are in one of the plaintiff groups that have brought these lawsuits in other states. So really great questions. And how does that impact things here in Massachusetts? So the good news is that the cases that are being litigated currently and the preliminary injunctions that have issued in those many cases, I think at one point, at last count, they were impacting U.S. DOE's enforcement of Title IX in 26 states, not Massachusetts, but it seems extensive, but the thing to remember is that in those cases, the courts have said, for the most part, that there's nothing in the pending litigation, so the cases of the states and plaintiff groups against the United States Department of Education, that prevents a school from adopting and enforcing its own policies with respect to sex-based discrimination, including choosing to comply with Title IX, the new Title IX regulations. So what those cases are really all about are and what the current injunctions are that are in place do is they prevent the U.S. Department of Ed from enforcing Title IX in those states, or in certain states with respect to certain plaintiff groups, students. So all of that is to say, what does that mean here in Massachusetts? And that's a question that we get or we have received from some folks. The thing to keep in mind is that Massachusetts public schools and private schools that receive federal financial assistance may adopt and maintain anti-discrimination and anti-harassment policies that are compliant with state and local laws. You have to do that, and that align with the 2024 Title IX amendments. So Massachusetts law and DESE's policies, again, have included robust protections against sex-based discrimination for many years, including protections that are captured more explicitly in the 2024 Title IX regulations, including protections against discrimination based on gender identity, sexual orientation, and pregnancy and related conditions. I do just want to say a quick thing. This is a question that we get a lot. So oftentimes, and this was true under the 2020 regulations as well, very often we will get questions about what's the intersection between Massachusetts bullying law, our bullying prevention and intervention plan, and Title IX and other civil rights-based harassment statutes. The thing that I always just try to remind folks is there may be cases where you have a situation that might involve your bullying policy and the state's anti-bullying statute. and Title IX or Title VI or another federal civil rights-based statute or state civil rights-based statute. The thing to keep in mind, just at a very high level, quick snapshot view, is that to remember that bullying under Massachusetts law requires is the repeated use of by a student or staff or all the folks mentioned here, bus driver, athletic coach, etc., that is directed at a victim. So that's important to remember. So there has to be a target, right? It can't be that situation I described where it's a bunch of students joking in the hall, because there's no, it's not directed at anyone. It's not directed at a victim. And then the result has to be causing harm in some way. So one of these types of harm to person, property, infringing on rights, and so forth. The takeaway is, without spending too much time on this, is just to remember or remind you that conduct may violate state and federal civil rights laws, including Title IX, even if it's not repeated and even if it's not targeted at a particular individual. This is why you need to consider that climate and culture, right? So we could have a long conversation about sort of nuances there, but just keep that in mind. I do want to just talk very briefly about jurisdiction. So jurisdiction requirements or the application of jurisdiction has changed just a tiny bit, or maybe a tiny bit, but the implications are different. And so this is important to think about when you're thinking about whether Title IX applies to the situation or not. So under the 2024 regulations, a school has jurisdiction over, and therefore an obligation to respond to, conduct that occurs in its education program or activity, period. So that's regardless of geographic location and regardless of whether the complainant is still a student or an employee at the school. So this is a shift, right? So under the 2020 regulations, a school's jurisdiction over allegations of sexual harassment, remember that was the language of the statute at the amendments at the time of the regulations, only extended to conduct that was alleged to have occurred against a person in the United States. So folks might remember this language in the school's program or activities. So there was, in other words, there was no jurisdiction over school programs or activities outside the United States. So foreign exchange programs, for example, even if it was the school's program, but it was outside of the United States, it likely didn't, Title IX likely didn't apply to the situation in terms of the school's jurisdiction. And there was also this other sort of area that wasn't covered, which is that there was no jurisdiction over complaints by former students or employees. So oftentimes you would get, I've had this situation happen where a school will call and say, we got an allegation of a Title IX violation against a former coach or former teacher by someone who just graduated. So graduated last year, does Title IX apply? Under the 2020 regulations, it likely did not. Now, there may be other policies that apply, the school policy, employment policies, and so forth, but from a pure Title IX standpoint, it likely didn't. So that is a shift that folks should keep in mind, that under the new regulations, there aren't those limitations. So what is the school's duty to respond? What do you do when you hear, and Eric will spend some time really walking through, like, what are the changes to the grievance policy? Like, how does our grievance policy have to change? What's different in terms of what we actually have to do? And Eric will spend some time walking you through that in a more detailed way. But I want to just talk now about sort of broad duty to respond. Like, what's the school's obligation when you learn of a potential violation to Title IX? So first, schools must provide full protection from all forms of sex-based discrimination and harassment. So it's not just sexual harassment. It means, discrimination on the basis of pregnancy and related conditions, for example. Schools must take prompt and effective action to end any discrimination, prevent its recurrence, and remedy its effects. So this should not be a new concept, right? So these are the things that OCR, Office for U.S. Office for Civil Rights, U.S. DOE's Office for Civil Rights, will always be looking for, right, when they get a complaint of any civil rights violation. If they find a violation, the expectation is, or what they'll be looking for is, did the school end the discrimination? Did they take reasonable steps to prevent its recurrence, and did it remedy its effects? So that's not a new concept, or shouldn't be a new concept. Schools must also provide supportive measures to complainants and respondents affected by conduct that may constitute sex discrimination. This concept of supportive measures is not new. This was a concept under the 2020 regulations. Eric will talk a little bit about how that's changed a little bit, but that concept is still included in the 2024 regulations. And schools must promptly and effectively respond to all complaints of sex discrimination with a fair, transparent, and reliable process that includes trained, unbiased decision makers to evaluate all relevant possible evidence. So this concept of fair and unbiased process, fair and unbiased due process is not new, but there are some tweaks to it, some nuances that are different. So prompt and effective action, again, means to end the harassment or discrimination, remedy its effects. What does that mean? It also means, again, considering the impact of any discrimination or harassment on the school climate and culture. And again, when I say consider it, it's not just consider it, but you should document how you considered it, how you responded to it. And you need to prevent its recurrence and document how you did that. So for individuals, that may be a safety plan, for a student, for a student or an employee, it could be some sort of discipline, restorative justice. And then again, thinking about school-wide remedies, efforts to prevent recurrence, reviewing your policies and practices, when an incident happens, particularly one that affects climate and culture. If you have a culture of discriminatory or if you have a discriminatory climate and culture, if that's a finding, you certainly are going to want to take actions well beyond the particular individuals involved. You're going to do a deep dive and think about, like, what do we need to do to right this ship in terms of civil rights? And so that can involve not just reviewing practices and policies, but feedback from stakeholders. So, circles to talk about, like, what went wrong and how can we fix it? And that's not just staff, it's, students, families, board of trustees, all of that. So just depending on the nature and scope of the issue. So employee duties and responsibilities, so getting down to employee level from what the school's responsibilities are. Duty to report. All elementary and secondary school employees who are not confidential employees, there again, new concept, and we'll talk about that in the next slide. But all elementary and secondary school employees who are not confidential employees must notify the Title IX coordinator when they have any information about conduct that reasonably may constitute sex discrimination under Title IX. Again, Eric's going to talk about training. This is why training is important, because in order to know what you should report, all employees must know, like, well, what is the new definition of conduct that I am supposed to report? So understanding the changes to the definitions of sex-based harassment and discrimination is important. There may be other reporting requirements in addition to Title IX. So nothing about Title IX's obligation or mandated reporting with respect to Title IX. Nothing about that changes obligations that employees may have under other state or federal statutes. In particular, I'm thinking about your mandated reporting under Chapter 119, Section 51A. Nothing about that's changed. And also confidential employees, so confidential employees that we'll talk about next, they may also still have obligations under mandated reporting as well. If that's confusing, throw a question in the chat. I'm happy to talk about that in more detail, because we do get questions about that. All right, so last thing I'm going to cover before I hand it over to Eric is this concept of confidential employees. New concept, right? So this is not something that we remember from the 2020 regulations, but it is new. Some folks may remember this was in the proposed regulations as well. I did a training on the proposed regulations. This is kind of being batted around as a potential concept, and it made it into the final regs. So a confidential employee is an employee of the school whose communications are privileged and confidential under state or federal law. So that means somebody's communications are already considered confidential. So think about the school nurse. If you have a mental health professional that's a school counselor or somebody like that, somebody whose communications are already privileged would be considered to be a confidential employee under the Title IX. It can also include any other employee or another employee that the school designates as a confidential employee. So in addition to the folks who already would kind of be considered confidential employees by the nature of their work and their position, their licensure, The school can designate confidential employees. It's an option, something to think about when you're doing your Title IX policy. Again, we have template policies that, are not template policies, but customizable policies that we've prepared for some of our clients. And that's one of the questions we ask them, do you want to have designated confidential employees? And then we kind of talk through like some consideration and why you would or wouldn't want to do that, but the school can decide. The whole purpose behind having a confidential employee or their role is that they're not required to report allegations of potential discrimination, sex-based discrimination to the Title IX coordinator. So remember, we just said on the last slide, like all employees have to report unless you're a confidential employee. So it's kind of think about it as like a safe space for someone to kind of talk about a potential allegation or have a conversation about whether they would want to report it to the Title IX and engage in the Title IX grievance process or not. That confidential employee is like a safe space to do that. Confidential employees do have a fee, in addition to any mandated reporting that they may have, putting that aside, the employee's status as a confidential employee, employee status as confidential in the circumstances under which the employee is not required to notify the Title IX coordinator. That's sort of the concept of it, right? But they do have to, so it's that safe space, but they do have a couple of obligations, and that is to to tell the individual how to contact the Title IX coordinator and how to file a complaint if they decide to do that. So you don't have to share that yourself as a confidential employee, but you need to tell the potential complainant, like, if you decide you want to do this, here's how you do it. And they also have to be trained at least and are familiar with the ways in which the Title IX coordinator would respond. So then when the person says, well, if I want to file, like what will happen? They have to have enough information, knowledge, and training to be able to explain to the potential complainant, like, here's what the Title IX coordinator might do. Might offer you supportive measures, will help you initiate an investigation and so forth. We'll tell you about informal resolution if your school offers that and so forth. So that's confidential employees. I know folks may have questions about that, but I do want to hand things off to Eric, who will share with you all that you need to know about the grievance policies and procedures that you should have in place, because just a reminder, all of this went into effect on August 1st. So if you haven't done it, Eric will tell you what you need to know.
Yeah, thank you, Bettina. And so as Bettina mentioned in some of the previous slides, schools have a duty to respond once they become aware of conduct that may constitute sex discrimination under Title IX. And so over the course of the next few slides, we're just going to talk through what that response looks like and some of the requirements for the Title IX grievance procedures. So the grievance procedures must require that parties, that would be the complainant, the person who experienced the alleged sex discrimination, and the respondent, the person accused of engaging in that conduct, they must both be treated equitably. There should be no conflicts of interest or bias from anyone involved in the Title IX grievance process. And so that includes Title IX coordinators, investigators, and decision makers. There's to be a presumption of the respondent's non-responsibility during the grievance process. And that just means that a respondent is presumed to have not violated the Title IX policy unless and until a finding of that violation occurs following an investigation and a report. So until the conclusion of that grievance process, a respondent is to be presumed to have not violated Title IX. The grievance procedures have to call for reasonably prompt timeframes. One thing of note in looking at the 2024 regulations versus some of the changes we saw in 2020 were that the 2020 regulations included some specific timeframes. For example, 10 days was specified as the amount of time that parties should have to respond to evidence collected over the course of the investigation under the 2020 regulations. But under the 2024 regulations, those sorts of specific timelines have not been offered. Instead, it's the case that schools should give reasonably prompt timeframes. Now, what is reasonably prompt will depend on a number of factors, including the number and type of allegations, the number of parties and witnesses. Just because I'll note, it is certainly the case that there can be multiple complainants in one matter or multiple respondents in one matter, as opposed to just one individual complainant against one individual respondent. There could also be variation based on the volume of evidence that is collected over the course of investigation and any extensions that are granted over the course of the investigation. Next, the grievance procedures need to take reasonable steps to protect the privacy of parties and witnesses. So the 2024 regulations hold that the school is not to disclose the personally identifiable information of students absent certain specific circumstances, such as to comply with federal law or to carry out the purposes of Title IX, or if there was voluntary written consent for that disclosure. Um, it's also the case that in sharing certain information under the Family Educational Rights and Privacy Act, also known as FERPA, a lot of that information can and should be redacted. So those redactions may look, for example, like having the black bar over the information, for example, a student name, or perhaps it's replaced with a label or a nickname or something of that sort uh, uh, for the purpose of protecting the privacy of those involved. The grievance procedures also have to call for an objective evaluation of relevant evidence and a prohibition against retaliation. And so the prohibition against retaliation extends to all people who are participating in the Title IX grievance process. Um, and so the school has to prohibit retaliation, including peer retaliation, and respond to allegations of retaliation in accordance with its Title IX policy and grievance procedures. And so we move to the next slide. This is kind of just showing the various steps of the grievance procedures. You'll note that we also included a graphic along the top of the slide just to kind of help us figure out exactly where we are in the process. But ultimately, the grievance procedures involve the filing of a complaint. There would be initial review to determine whether or not to open that complaint for investigation. If it does open for investigation, a notice of allegations is issued to the parties. The parties have an opportunity to respond to that notice of allegations. After that, the investigation really picks up in terms of interviews conducted, evidence collected. Then the relevant evidence or summary of that evidence is shared with the parties so that they again have an opportunity to respond. Then there is an optional live hearing that can occur. That's up to the school to determine whether they wish for there to be a live hearing. After which there's a written determination. If there wasn't a live hearing, then the written determination would occur at the conclusion of the investigation. And then finally, there is the right of the parties to appeal. So we're going to go through each of these in more detail on these coming slides. And so we'll start with the complaint. So one of the most notable differences between the 2020 Title IX regulations and the 2024 Title IX regulations is the form of the complaint. So in 2020, a Title IX complaint had to be in writing. It had to be written and signed. And that's not the case under the 2024 regulations. Under the 2024 regulations, a complaint may be oral or written. And when we look at the complaint, it could be filed by a complainant. Again, a complainant is the person who experienced the alleged sex discrimination. The complainant can be a student, an employee of the school, or any person who is participating or attempting to participate in the school's education program or activity at the time of the alleged sex discrimination. So this means that a complainant could be an alumnus of the school, someone who experienced alleged sex discrimination back when they were a student, or someone who was a former employee, or even someone who was uh, applying for enrollment at a school, someone going through the admissions process. A complaint can also be filed by a parent, guardian, or legal representative of a complainant, or in certain circumstances by a Title IX coordinator. And the other thing that we really want to highlight about the complaint is that a complaint has to objectively be understood as a request for the school to investigate that alleged conduct and to determine whether it constituted sex discrimination under Title IX. And so that means that there has to be that element of requesting an investigation, of ultimately requesting that grievance procedures um, take place, as opposed to simply stating, this thing happened, period, full stop. A complaint has to involve that extra element of there being this kind of request for the school to investigate and to make a determination as to whether sex discrimination occurred under Title IX. And right before moving to the next slide, ultimately the Title IX coordinator is going to be the person or persons tasked with coordinating the complaint and kind of what happens throughout the grievance procedures. So each school has the responsibility to designate at least one person as a Title IX coordinator. And as I just mentioned, the Title IX coordinator is tasked with coordinating a school's efforts to comply with Title IX. The name and contact information of the Title IX coordinator needs to be shared with students of the school, parents, guardians, and legal representatives, employees, applicants for admission, and also unions and other professional bargaining organizations. And the information about the Title IX coordinator needs to be appropriately published in various sites, including the website, the school's handbooks, and recruitment materials. Okay, so if we move to the next slide, we just kind of wanted to go over what some of the responsibilities of the Title IX coordinator are. So as indicated, the school has to designate at least one person to be a Title IX coordinator. And when the Title IX coordinator is notified of conduct that may reasonably constitute sex discrimination, then, as Bettina mentioned previously, the Title IX coordinator has responsibility to take actions to promptly and effectively end that alleged sex discrimination, to prevent its recurrence, and to remedy its effects. And there are a few specific things that Title IX coordinators are required to do in furtherance of those goals. So a Title IX coordinator is to ensure that complainants and respondents, again, the parties to a Title IX matter, are treated equitably. Title IX coordinators are to offer and coordinate supportive measures to both complainants and respondents as appropriate. And I'll speak about that in more detail in some future slides. A Title IX coordinator is to notify the complainant and respondent as appropriate of the school's grievance procedures and of any informal resolution process that the school has decided to take on. In response to a complaint, the Title IX coordinator is responsible for initiating the grievance procedures or, again, that informal resolution process if available. And I'll describe the informal resolution process as well in some future slides. And then we see here for the sub-point, the Title IX coordinator, whether there is a complaint filed or not, if the Title IX coordinator becomes aware of conduct that may constitute sex discrimination, they still have that responsibility to take those actions to promptly and effectively end it, to prevent its recurrence, and to remedy its effects. It's also the case that Title IX coordinators may themselves file complaints. If it's the case that a complainant either does not file a complaint or wishes to withdraw any or all of the allegations in the complaint that they filed. And so the regulations give some specific considerations for the Title IX coordinator to think about in that sort of occasions. For example, has a complainant objected to an investigation proceeding? And if so, why? Are there safety concerns? What are the nature of the allegations? Uh, is it the case that there was an impact on a larger population or more broadly across the school? So a number of considerations that a Title IX coordinator should make to determine whether or not in their own capacity they should file a Title IX complaint. And so if we move to the next slide, I want to get into the supportive measures. And so supportive measures were discussed in both the 2020 regulations and the 2024 regulations. However, there's a notable difference in that the 2020 regulations really specifically discussed supportive measures with regard to complainants. Again, that's the person who experienced the alleged sex discrimination. But the 2024 regulations actually say that supportive measures should be offered to both complainant and the respondent. And so that's a notable thing to keep in mind. Now, the purpose of supportive measures is to preserve a party's access to the school's education program and activities, including to protect their safety during any sort of grievance procedures related to Title IX, whether that be the investigation process or the informal resolution process. And supportive measures, as explained in the 2024 regulations, need to be individualized to the recipient. They should be offered as appropriate, as reasonably available to the school, and without unreasonably burdening a party. Supportive measures should be non-punitive and non-disciplinary. They should be offered without a fee or a charge to any party. And supportive measures should be kept confidential, such that they are shared pretty exclusively with the person receiving those supportive measures, as opposed to informing other parties of supportive measures that are kind of being offered and received by a separate party. So if we go to the next slide, we wanted to give a few examples of what supportive measures can look like. And so supportive measures include, but are not limited to, the list we have here. And so we've got counseling, extensions of deadlines, increased security and monitoring, restrictions on contact applied to the parties, leaves of absences, and the changes in classes, work, housing schedules, things of that nature. But we do want to highlight, and picking up again on one of the things mentioned on the last slide, that if a Title IX coordinator is working to coordinate supportive measures for a party, it's important to remember that supportive measures are not to be punitive or disciplinary. So you really should be mindful about potentially changing anyone's class schedule, for example, prior to there being a determination as to respondent's responsibility, because again, you don't want there to be the implication that the supportive measure was actually punitive against any of the parties. Okay, so if we move to the next slide, please, we'll get to the initial review stage. So if a complaint is filed, again, that's an oral or written complaint indicating that conduct that may constitute sex discrimination under Title IX has occurred and that this person would like the school to investigate that and to make a determination, the Title IX coordinator will receive that complaint, and then they have to determine, based on their review, whether to open that complaint for investigation or whether to dismiss it. And so a complaint can be dismissed for any of the following reasons. One of the main things to keep in mind is that a complaint may be dismissed if the conduct alleged, even if it were true, would not constitute sex discrimination under Title IX. Now, it could be the case that the alleged conduct implicates other school policies, but if it wouldn't constitute sex discrimination under Title IX, if it's not that unwelcome conduct on the basis of sex, which leads to a hostile environment or that had those quid pro quo dynamics, then that would be a reason to dismiss the complaint under Title IX, and it may be rerouted as appropriate. A complaint may also be dismissed if the school is unable to identify the respondent after taking reasonable steps to do so. So, for example, perhaps it's the case that the respondent is no longer affiliated with the school. The school has to determine whether or not it would make sense for an investigation to proceed. What, if anything, might happen if there were a finding that respondent had indeed violated the Title IX policy. A complaint could be dismissed for looking at the final point. Again, if the complainant voluntarily withdraws any or all of the allegations in the complaint and the school and or Title IX coordinator review any of the remaining information and determine that that wouldn't constitute sex discrimination under Title IX. And so we move to the next slide. If it's the case that the Title IX coordinator determines that the conduct alleged may constitute sex discrimination, then an investigation will be opened, an investigator will be assigned, and then a notice of allegations will be issued to the parties. And so at this stage, we just kind of wanted to review some of the cast of characters who may be involved in the Title IX grievance process. And ideally, there is no overlap between these people. Largely because you want to make sure that you have various people trained to take on these roles, so as to avoid any issues with conflict of interest or bias. And running through some of these people, there's the complainant. Again, that's the person who experienced the alleged sex discrimination. The respondent is the person accused of engaging in that conduct. The Title IX coordinator is the person who's been tasked with coordinating the school's Title IX efforts and their responses to any conduct that may constitute sex discrimination. Then we have the investigator who would be conducting the investigation, anyone designated by the school. Next, we would get to the decision maker. This would be the person to determine, following an investigation, whether or not the conduct alleged occurred and constituted sex discrimination under Title IX. We have here in parentheses, ideally, your decision maker is not going to be kind of the highest professional position at the school. And that's largely because the next character we have here on our list, the appeals decision maker, that's going to be the person who handles any appeals. And so ideally, this would be somebody who is higher kind of in the chain of command than the decision maker. And then finally, at the very bottom there, if the school decides to offer an informal resolution process, which again, I'll describe in a bit more detail moving forward, but there would be a person to facilitate that process. And so it's certainly the case that your school could have a person in that role as well. Okay, so as I mentioned, There's such a thing described in the 2024 regulations as the notice of allegations. And so, say the complaint was filed, the Title IX coordinator conducts an initial review, determines, yep, this conduct, if true, would constitute sex discrimination under Title IX. And so the next step would be to issue a notice of allegations to the parties. Now, that notice of allegations informs the parties of the conduct alleged that was opened for investigation and of the school's Title IX grievance procedures, i.e., the initiation of this investigation. Now, the notice has to include a few specific things. The grievance procedures, including the presumption that the respondent is not to be considered responsible for a Title IX violation until the conclusion of the Title IX grievance procedures. The notice of allegation should include sufficient information available at the time to allow the parties to respond to the allegations that have been open for investigation. So the 2024 regulations actually give examples of what that sufficient information would include, and that would be the identities of the parties involved, the conduct that's alleged to constitute sex discrimination, and the dates and locations of any alleged incidents. The notice of allegation should also include the statement that retaliation is prohibited and a statement that the parties are entitled to an equal opportunity to inspect and review the relevant evidence collected over the course of the investigation. And so the notice of allegations, like many of the steps kind of coming up in the grievance procedures involves certain specifics as outlined by the 2024 regulations. It can be really helpful for a school to have template forms for these notices and letters. And so we here at Krokidas and Bluestein have prepared a number of those forms and documents just to make sure that all of the points required by the 2024 regulations are included. And so I'll make mention of that as we go to some of the others. And so here, moving along the grievance procedures, after that notice of allegations goes out to the parties should be granted sufficient time along that reasonably prompt time frame to respond to the notice of allegations. And whatever that amount of time is, that reasonably prompt time frame, it should be such that the parties have time to respond prior to any initial interview conducted by the investigator. Okay, we move on to the next slide. Um, Now I just want to give a little bit more information about informal resolution, which has come up a few times so far. So ultimately, the 2024 regulations state that a school can offer an informal resolution process. Um, and if the school decides that they will be offering an informal resolution process, which, as the name suggests, is ultimately just an informal process outside of the grievance procedures that would allow for the resolution of this matter, but doesn't involve the investigation and official determination as to whether there was a Title IX violation. So if a school has decided to take on an informal resolution process, then at any time prior to determining whether sex discrimination occurred, a school can offer that informal resolution process to the parties, unless the complaint includes allegations that an employee engaged in sex-based harassment of an elementary school or secondary school student, or if such a process would conflict with federal, state, or local law. Informal resolution is at all times voluntary to the parties, and a party can decline to participate or withdraw from participation at any time. So even if it's the case that the school has adopted within its own grievance procedures an informal resolution process, the parties can decide, yes, they'd like to participate, or no, that they would not. Um, and it's also the case that a school that provides the parties with an informal resolution process should also require its Title IX coordinator to take any other appropriate steps as needed, again, to prevent any sex discrimination that may occur, to address any sex discrimination that may occur, to prevent its recurrence. That should always be kind of on the mindset of the Title IX coordinator. That's always in the background. So moving on to the next slide, please. And getting back to the grievance procedures, the investigation was opened, the parties were notified in that notice of allegations, the parties had an opportunity to respond to that notice of allegations, and then we move into the evidence collection phase. And so the burden is on the school, not the parties, so not the complainant, not the respondent, to conduct an investigation that gathers sufficient evidence to determine whether or not sex discrimination actually occurred. Now, equal opportunity is to be given to the parties to present fact witnesses and other evidence that is relevant and not otherwise impermissible. And I'll get into those definitions in the coming slides. Over the course of this evidence collection phase, interviews can be conducted with parties, with witnesses, just with people who have information about the allegations open for investigation. And the information that's ultimately gathered and collected over this period should concern those allegations open for investigation, as well as the credibility of the person providing the information to the extent that credibility is both in dispute and relevant. And so, for example, the Department of Education did not specifically define credibility in this context, but at least one federal court noted that credibility could be in dispute and relevant if it were the case that the decision maker was relying solely on testimonial evidence or on narrative evidence between the complainant and respondent. Because if the only evidence that exists is this person's narrative account versus this person's narrative account, then the credibility of those speakers is certainly relevant. Okay, and moving on to the next slide, I wanted to speak here a little bit just about the relevant piece and speaking about the evidence. So it's the case that the grievance procedures need to give the parties an equal opportunity to access the evidence that is relevant, that's been collected over the course of the investigation, or an accurate description of that evidence as opposed to the full evidence. So if the school initially provides a description of the evidence or a summary of the evidence, the parties are entitled to review the full evidence upon request. Um, Evidence that is relevant is evidence that has to deal with the allegations open for investigation and evidence that would help the decision maker determine whether or not sex discrimination indeed occurred. Now, evidence that is impermissible is evidence that is not to be used or considered regardless of its relevance. And the 2024 regulations identify a few pieces of evidence that are just deemed impermissible. So, for example, evidence that's protected under a legally recognized privilege has been deemed impermissible unless voluntarily waived. For example, the privilege that exists between a client and their attorney. That would be information that would be impermissible. Another bit of evidence that's been deemed impermissible is evidence that relates to the complainant's prior sexual history, unless that evidence is offered to prove that someone other than the respondent engaged in the alleged conduct, or if the respondent and the complainant have some history with one another and evidence of their romantic history is being offered to prove that complainant gave consent for the conduct at issue. But it is the case that the evidence considered needs to be relevant and not otherwise impermissible, and the parties have the right to access that evidence. And so if we move along to the next slide, the parties have an opportunity to respond to the evidence. Again, there should be a reasonably prompt time frame that is implemented for that. And then moving on to the next slide, please. After the evidence is distributed to the parties or made available to the parties for their inspection and review, and the parties have an opportunity to respond as they see fit, schools have an opportunity, if they so choose, to conduct a live hearing. And so if a live hearing is conducted, the regulations are pretty specific as to what should occur during the hearing. So each party is entitled to an advisor who may be, but doesn't have to be an attorney. The parties may be physically present in the same location, or they may be physically present in separate locations, but with technology that allows everyone to see what's going on in real time. The school should be creating an audio or audio-visual recording or a transcript that'll be available to the parties upon request. At the request of a party, the school should make any accommodations, including for translation or interpretive services. If there's a live hearing, then questions may be asked by the decision maker or by a party's advisor, but never by a party directly. And finally, if a school decides to incorporate live hearings into their Title IX grievance procedures, then questions asked, again, must be relevant and not otherwise impermissible, and the decision maker will determine whether those questions are appropriate prior to their being asked. Now, moving right along, we get to the determination. So, following an investigation or a live hearing, if one is conducted, then a written determination will be issued to the parties simultaneously, indicating whether, based on an evaluation of the relevant information collected, respondent's conduct indeed violated Title IX. And the standard of evidence that the decision maker is going to use in making that determination is the preponderance of the evidence standard, or more likely than not. So, the decision maker will look at all the relevant evidence collected and determine, is it more likely than not? Is it 51% or higher that this conduct occurred and meets the definition of discrimination on the basis of sex? And so I'm actually going to transition over, um, after after hitting this slide. I wanted to mention that the written determination has to, like the other forms, include some specific information, as detailed in the 2024 regulations. And so we have template forms for these, but the written determination has to include a description of the alleged conduct open for investigation, information about the policy and procedures that the school used to engage in its grievance process, the decision maker's evaluation and ultimate determination as to whether respondent's conduct violated Title IX. And then if it's the case that the decision maker finds that respondent's conduct indeed violated Title IX, then the decision maker can recommend any disciplinary sanctions that the school should impose against respondent, and any remedies that the school may want to provide to complainant, and to the extent appropriate, any other remedies that should be extended to others at the school who may have been impacted by respondents' conduct more broadly. And finally, the written determination needs to include information that the parties have the right to appeal that written determination. And so with that, I'll transition over to Bettina, who will speak a little bit more about what happens with the decision maker.
Thanks, Howard. All right, so decision maker considerations. So I saw that there are some questions in the chat that we will get to, or in the Q&A that we will get to, about how do you decide who serves in what positions? And we can talk about that. But right now, let's talk about, the decision maker and some decision making considerations. So the first being, who should be the decision maker? So the first thing is, these are decisions that are oftentimes more business decisions, or, for the school on, staffing and so forth. But some things that you should take into consideration. Conflicts of interest, right? So it can't be, in a particular case, it can't be an employee that reports to or is subordinate to the respondent. So obvious, has to be, remember, this is an unbiased process. So you have to consider conflicts of interest. So that's one consideration. And they must have the required training. And this is true for all of the Title IX roles, right? So they need to be trained on what are the grievance procedures, how to serve impartially, what's the meaning of relevance, like Eric just discussed, with respect to evidence, and what types of evidence are impermissible. So all of those things are things that the decision maker is going to be required to be trained on, be comfortable with, be able to put into practice in considering the evidence and the issues before them. So I did want to talk a little bit about the relationship of decision-making, the decision-making considerations and student discipline, and how does Title IX sort of interplay with the student discipline process? Because this comes up a lot, right? So you do a Title IX investigation, you find that a respondent did engage in the discriminatory conduct, but then what do you do with that? So once that you have that determination, how do you respond? Can you discipline? Can you discipline before that? As Eric talked about, you can't discipline before the process plays out, with the exception of emergency removal that I'll talk about in a sec. So disciplinary sanctions under Title IX, again, not permitted prior to the conclusion of the grievance process. Emergency removal, there's nothing in Title IX that precludes a school from removing a respondent from the school's education program or activity on an emergency basis, provided that the school undertakes an individualized safety and risk analysis, determines that an imminent and serious threat to the health or safety of a complainant or any other students, employees, or other persons arises from the allegations of sex discrimination, and that justifies removal, and provides, and you also, of course, have to provide the respondent with notice and an opportunity to challenge that decision, that emergency removal, immediately following the removal. So if there's an emergency removal situation, the thing to keep in mind, if you need to emergency remove a student while the Title IX process plays out, you of course want to remember to follow the due process procedures under state law. So 603 CMR 53.07 at SEC. You want to make sure to comply with the emergency removal due process. You also want to consider other due process requirements under the IDEA in Section 504. So here specifically talking about manifestation determinations if applicable, if you're removing or emergency removing someone. So I just wanted to mention that. And then just briefly want to talk about appeals. Folks that have been doing title process or have been engaged in the Title IX process over the last few years know that appeals are few and far between typically. Some schools probably have never seen an appeal. So, it's unusual, but that's not unheard of. And I've seen, some schools where they've had a few because they just have a number of Title IX matters that have come through. So either party may appeal the dismissal of a complaint or determination of whether sex-based harassment occurred on the following bases. So again, these probably look familiar to folks under the previous regs. Procedural irregularity is a basis for can be a basis for appeal. New evidence that would change the outcome, and that was not reasonably available. So that's kind of an important factor, right? When the determination or dismissal was made, conflict of interest or bias on the part of the Title IX coordinator, investigator, or decision maker, either against the complainant, either against sort of complainants generally or respondents generally, or against any of the particular individuals involved. That would change the outcome. So again, this kind of goes to not only training on the process for Title IX, what do you need to know, what do you need to consider, but also take training on conflicts, bias, and perceived conflicts and bias. And how that plays into the process is important as part of any sort of training program that you have for staff, or in particular Title IX staff. So due process, if you get an appeal, there's of course a notice requirement. You want to ensure that the appeal procedures are implemented equally for parties, ensure that the decision maker for the appeal did not take part in the investigation of the allegations or dismissal of the complaint, again, going to this concept of being unbiased. Ensuring that the decision maker for the appeal has been trained, obviously, in all of the requirements of Title IX regulations. Provide the parties with reasonable and equal opportunity to make a statement in support of or challenging the outcome. So, they get the decision of the decision maker. They have an opportunity to sort of say something for or against that, or anything they want to say about it, and have that be considered by the appeal determiner or arbiter. You want to notify the parties that appeal, once the appeal decision is done, parties need to be provided that determination, the result of the appeal, and the rationale. Best practices for that to be in writing, because it creates a record and you can keep that with your Title IX files. And that was all I wanted to tell you about decision making and appeals, but I do want to hand it back to Eric to emphasize the training requirements, which are really important. So handing it over to Eric.
Thank you, Bettina. So now we're moving down to the final two topics that we wanted to cover as a part of this webinar on the 2024 Title IX regulations. So training. All employees of a school must be trained on the school's obligation to address sex discrimination, the scope of conduct that may constitute sex discrimination under Title IX, and all applicable notification and information requirements that are imposed by the 2024 regulations. And you see we have this extra note towards the bottom here just to give extra context into the meaning of employees as used in the 2024 regs. And so employees includes individuals who are employed directly by the school, as well as independent contractors, volunteers, advisors, and third-party agents who are otherwise kind of taking on roles involved in the Title IX grievance process, such as roles and responsibilities similar to that of a Title IX coordinator, investigator, or decision maker. Now, in addition to the training requirements for all employees of the school, all Title IX coordinators, investigators, decision makers, appeals decision makers, and other persons who are responsible for implementing the school's Title IX grievance procedures or otherwise involved in the informal resolution process also must be trained on what it means to be involved in the Title IX grievance procedures. So those people must be trained on the school's obligation to respond promptly and effectively, the school's grievance procedures, how to serve impartially, and topics of conflict of interest and bias. And those people are also need to be trained on the meaning and application of the term relevant as pertains to questions and evidence. Title IX coordinators and their designees must also be trained on their specific responsibilities, and the same can be said for any facilitators of an informal resolution process, which again, as we discussed, is a process that schools can decide to incorporate into their grievance procedures. Now, finally, we wanted to discuss record keeping. The 2024 Title IX regulations state that the school must maintain for a period of at least 7 years records on the following: records of each complaint of sex discrimination and records documenting the grievance procedures or the informal resolution process and the outcome. There should be records documenting each notification that the Title IX coordinator receives of conduct that may constitute sex discrimination under Title IX. And there should also be records maintained for the trainings that occur for Title IX coordinators, investigators, and others involved in the Title IX grievance process. Now, you want to be clear on who is responsible for maintaining records. It's very important that the records are maintained, and so you just want to make sure that whoever your school has designated as your record keeper is aware that certain records need to be maintained in terms of Title IX as well. And then the last thing I want to note, just in mentioning that training materials are to be maintained, is that in the 2020 regulations, training materials were required to be posted to a school's website, and that is not the case under the 2024 regulations. Under 2024 regulations, the trainings don't need to be posted to a website, but they do need to be made available for inspection and review upon request. And so with that, we've ultimately been able to go over the topics that we hope to cover from the 2024 Title IX regulations. We thank you for your attention. Um, We'll send the slide deck and a Q&A document to all of the attendees of this webinar. Please contact us here at Krokidas and Bluestein if you have any additional questions about Title IX, or if you are looking for a model Title IX policy or any template forms, all of which we have prepared. And so we thank you again for your time and attention.